proceedings from called for from the District Court Surat. The said is to be reached on or before 15th of May with special messenger. The record is to be sent to this court. So in vacation, I am able to conclude the dictation part. Yes.
We would be constrained if we ask for an interim order.
Interim order,
We are like,
yes, you can certainly make a request, but that,
That will be allowing
Yes.
the petition.
Yes.
On the first principle, it cannot be granted.
that's
Yes.
only if I make.
Yes, yes.
You have not made, therefore I am
Yes.
not rejoining.
no. 15th is for,
Record
now
will-
today I am completing the hearing. Even it is not
Hearing will go
concluded
on.
today, then tomorrow. I will conclude the hearing, that part is over. Now, so far as the passing the order, that is I am keeping after during the course of vacation and reopening of vacation.
Can I give you the entire certified copies compilation in the meantime?
Yes, in the meantime, certainly you can.
So I will
Yes.
write now.
Yes. 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 The learned counsel, Mr. Chapaneri, requested that they are having all the certified copies from the trial court. And they are permitting to produce all the certified copies on the. Yes. 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 Yes, yes, sure.
Now, since
So last occasion, we.
petitioner side has
Yes,
made their
yes.
submissions, I am,
Yes.
first of all, have to submit because they objected that I don't have any audience now. As if
That part we have now considered and now
Then-
you
then
can
I need not
argue the
give-
matter.
I am obliged.
We'll-
Otherwise, I
we-
was to just make very
No.
brief submission.
You,
That I am party, I am complainant and I can be heard. Now, the first thing therefore, the much emphasis is laid
yes,
by the learned counsel appearing for the petitioner
yes,
that the offense is not serious. And court will have to see seriousness while considering an application under section 389(1) for the stay of the conviction.
yes,
In my humble submission, the seriousness of the offense can be considered keeping in mind the different aspects. One of the aspect is that what sentence is provided.
yes,
The second aspect is that what is the effect of such offense on the victims or the society at large. But here, my lord, the parliament itself, while enacting subsection 3 of section 8 of Representation of People Act, has considered such convictions where sentence is imposed which is 2 years and more as a serious offense which can incur disqualification. Therefore, in my respectful submission, when Parliament says 2 years is sufficient if one member is convicted to disqualify him, in my respectful submission, that contention raised about seriousness of the offense is already below. Parliament has, by enacting the law, provided that this is serious so far as continuing as member of this house is concerned.
yes,
So one who has attained or one who is convicted and ordered to suffer sentence of 2 years and more, then he stands disqualified. And that is what Parliament itself says for their own members.
yes.
Kindly, my lord, I will read subsection 3 of section 8, my lord. Because subsection 1, my lord, enlists the other offenses where even 6 months sentence is treated as enough for disqualification. I am not bothering my lord by reading that entire section. Give me 8. Yes. Kindly see, my lord. a person convicted of any offense and sentenced to imprisonment for a not less than 2 years, then bracket, other than offenses referred to in subsection 1 or subsection 2 shall be disqualified from the date of such conviction and shall continue to be disqualified for a further period of 6 years since his release.
Yes.
So, my lord, in my respectful submission, that seriousness is considered by Parliament itself. Because this is the only consequence which is placed into service. That this will be an irreparable injury. This is irreversible. I will suffer. I will not be able to contest. I will not be able to continue as MP. No other grounds are stated, neither in the petition nor in the submissions. The only sufferance which is shown is that I will lose my membership and I will not be able to contest. Now that sufferance is, provided by Parliament itself, not by the court. Court has not disqualified you. Neither the trial court, nor even the complainant's complaint has disqualified you. It is the law made by Parliament disqualifies you because it is 2 years. Had it been here 5 years, then 5 years, 7 years, then 7 years. But 2 years. And the sentence imposed is 2 years. So this is first ground. Therefore, seriousness is not to be judged here at this stage. When your lordships are considering a revision application against an order of passed by the Sessions Court, rejecting the prayer of 389(1) for stay of the conviction. Sentence is suspended, undoubtedly. So this is first part so far as seriousness is concerned.
Yes.
And he is therefore visiting with this eventuality of disqualification because of the operation of law, not because of any judgment. Judgment is after the adjudication, appreciation of evidence led, judgment imposes this sentence. There the court's function has ended. Appellate court will consider validity of that judgment at the relevant time.
Yes.
But the law enacted as whatever I wanted to
Yes.
submit, I'm briefly submitting on
Yes.
this issue. The second aspect is that why such subsection 3 is immoral. There's a reason behind it. To maintain the dignity, sanctity, and purity of the highest constitutional body of the country. That we don't have members in our house, if it is elected to continue as members of Parliament, if they are sentenced to suffer sentence of 2 years and more. And that is the obvious object and reason for enacting these provisions of disqualifications. The Constitution of India is not providing or any act, like Representation of People Act, for qualifications to become member. Yes. But disqualifications are provided, taking aid from Article 101, 102 and other articles. I am not taking your lordship so that to show that all this is required, but disqualification provisions are there. Disqualification provisions operates on its own. Then, my lord, straight away I may invite my lord's kind attention to the judgment of Lily Thomas, my lord, where subsection 4 of section 8 is struck down as ultra vires, which otherwise was providing that if you just present an appeal within 90 days, then it is ipso facto automatic stay. The Supreme Court says that this can't be done. This is beyond your competence. And therefore, it is struck down. But while striking it down, my lord, kindly see relevant paragraph 34 and 35 of Lily Thomas, my lord. Running page number 157 to 178. Paragraph 34 and 35.
Yes.
we do not, this is why I'm not reading the other paragraphs for the time being, subject to my lords granting me permission. Because we are not on the, actually on subsection 3 of section 8 and other provisions, but the remediless part I'm just pointing. We do not also find merit in the submission of this so and so that if sitting member of parliament or the state legislature suffers from a frivolous conviction by the trial court or an offense given under subsection 1, 2, and 3 of section 8 of the Act, he will be remediless and will suffer immense hardship as he would stand disqualified on account of such conviction in absence of subsection 4 of section 8 of the Act. A 3-judge bench of this court in Ramanarang versus so and so has held that when an appeal is preferred under 374 of the Code of Criminal Procedure, the appeal is against both conviction and sentence, and therefore the appellate court in exercise of its power under 389(1) of the court can also stay order of conviction, and High Court in exercise of its jurisdiction under code also can stay conviction if the power was not to be found in 389(1) of the code. In Ravikant Patil, which is placed into service by the other side, paragraph 15 is quoted. 3-judge bench of this court, however, observed it deserves to be clarified that an order granting stay of conviction is not the rule but is an exception. I am placing this into service, to be resorted to in rare cases, depending upon facts of a case, where the execution of the sentence is stayed, the conviction continues to operate. But where the conviction itself is stayed, the effect is that conviction will not be operative from the date of the stay. An order of stay, of course, does not render the conviction non-existent, but only non-operative. Be that as it may, insofar as present case is concerned, an application was filed specifically seeking stay of the order of conviction, specifying the consequences of if conviction was not stayed, that is appellate would incur disqualification to contest the election. The High Court, after considering the special reasons, granted the order staying the conviction, as the conviction itself is stayed. Contrast to stay of execution of sentence, it is not possible to accept the contention of the respondent that disqualification arising out of conviction continues to operate even after stay of conviction. In the aforesaid case, a contention was raised by the respondent that the appellant was disqualified from the contesting the election of the Legislative Assembly under subsection 3 of 8 of the Act, as he had been convicted for offence punishable under 366 and 376 of the Penal Code, and it was held that 3-judge bench that as the High Court for special reason has passed an order staying the conviction, the disqualification arising out of conviction ceased to operate after the stay of conviction. Therefore, the disqualification 1, 2, and 3 will not operate from the date of the order, the stay of the conviction passed by the appellate court under 389 for High Court and court. But the purport of reading these two paragraphs is that they are not remediless. So remedy they have invoked, they have filed application, but it can be granted in exceptional cases, in rarest of rare cases, not rarest of rare in the context of death sentence to be avoided. I don't say, not pitching that high. But they must point out that it is a frivolous conviction. And if it is not pointed out, the frivolous can be from the allegations, trial, evidence which has come on the record, admissibility of the evidence, etc. The grounds are canvassed, but they are good for appeal, not for this application, in my humble submission. So, this is on that, their main submission is that I will lose my membership. I will not be able to contest in all for 8 years. I am out of the house. Now, there, with respect, I would like to submit of the facts of the case, that what were the utterances made and why the complaint was filed. Kindly see those utterances made, witnessed by and heard by a live witness, apart from electronic record. I am not entering into it. The evidence of we have filed those documents, yes.
Yes.
Give me page number. $36.
Yes.
But that is is exhibit 67. He says that I was present, etc. Page 37, my lord, may kindly see. તે પછી શ્રી so and so PM શ્રી so and so નામ લઈ તેમના વિશે ઘણી બધી બાબતો ઉપર બોલતા ગયા. Am I with my lord? Obliged. તેમણે પોતાના ભાષણમાં એવું કહ્યું કે નરેન્દ્ર મોદી પોતાની જાતને દેશના ચોકીદાર કહે છે, પરંતુ તે ચોકીદાર નથી, દેશના પૈસા લૂંટે છે. પછી એવું બોલ્યા કે પીએમએ દેશની ગરીબ જનતાના 30,000 કરોડ રૂપિયા સોના ખિસ્સામાં નાખી દીધા. તેમનું એવું કહ્યું કે રફાલની જે ડીલ થઈ તે સંબંધે સોએ ઉપરની રકમ સોના ખિસ્સામાં નાખી, ચોકીદાર નહીં પણ ચોર છે તેવું બીજી વાર દોહરાવેલ. પછી તેને સાથે સાથે ભાષણમાં એવું કહ્યું કે નીરવ મોદી છે તે પણ લોકોના પૈસા હડપી લીધા છે, ભાગી ગયેલો છે. લલિત મોદી પણ લોકોના પૈસા લઈ ભાગી ગયેલ છે. એક મેહુલ ચોકસી છે તે પણ પૈસા હડપી લીધા છે. એક વિજય માલિયા પણ લોકોના પૈસા હડપી દેશ છોડીને ભાગી ગયેલ છે. તેમણે તેમના ભાષણમાં એવું કહેલ કે દેશના ચોર લોકોના નામ મોદી 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 ऐसा ही क्यों होता है? એમણે એવું કહેલ કે આ મોદી લોકો ચોર હોય છે. I am Purnesh Modi. This sentence, my lord, covers all Modi, including me, and therefore I have filed the complaint. And if I am putting it to myself that if this is not defamatory, then what else can be the defamation? And then you say that I am sentenced to suffer 2 years. If you are Motormouth, if you are facing 12 such complaints today, you are even after the pronouncement of conviction, judgment, and disqualification order, my lord, I am placing that into service. It's a newspaper, I mean, it's from the portal. You copy to the other side. Sign. This is what his stand is, my lord. Page number. May I have to sign? Page 7. Congress leader. My name, may kindly see the title. This is after the disqualification. And this is neither, my lord, controverted, refuted, nor contradicted that I am misreported, misquoted, nothing. My name is Gandhi. I am not Savarkar. Won't apologize. Congress leader Rahul Gandhi on Saturday said that he was not Veer Savarkar and will not apologize. I am Gandhi and not Savarkar. And Gandhis do not apologize. He said at a press conference here, a day after his expulsion from parliament, following his conviction in defamation case. The former Wayanad MP thanked the opposition for the support and said his disqualification will be a weapon against Narendra Modi. I am happy that they have given the best gift ever. Have the gift. Why are you praying for this gift? Keep the gift with you. Enjoy the gift. He went to say that the country has given me love and respect, and alleged that his disqualification is because the Prime Minister is scared of his next speech in Parliament. The senior leader further said that he will continue doing his work and that it does not matter if I am inside the Parliament or not, I will keep fighting for the country. He said that his disqualification is directly related to Prime Minister, who does not want him to speak about his relations with so-and-so. Rahul said that the public knows that so-and-so is corrupt, and now the question is that why so-and-so is saving him from the investigation. He also said that he is not scared and will not stop asking questions about alleged relations. I will not stop caught. I will not Stop asking questions about whose money is 20,000 crore that has come out from the shell companies. I am not scared of prison, sentence, disqualification and others. I am not that type of person and they do not understand me. I am not going to back down and will stick on the principles. Even if I am disqualified for life, then also I will keep raising questions. Fight for the people, he added. My voice is being suppressed. Rahul Gandhi said and claimed that he spoke to the speaker against the false accusation made for minister. It was on Friday. That's all. That's all. This is where now this is the public stand. And the stand in the courtroom is different. This is all that my endeavor is to point. If this is your public stand, then whatever matters, disqualification or sentence or conviction, I will speak. Very well, if you are motor mouth, you speak. But then don't come with a prayer here. Here you are making prayer. You are well within your right not to apologize. Nobody can compel you to apologize. But then, for consequences, don't make you and cry like a crybaby. That look here, I will be removed, I will be disqualified. That cannot be done in my respectful submission. That is not done. Either you stick to your stand, which is your public stand, or you say that very well I spoke. I never meant that. I never intended that. I never wanted to defame anyone or humiliate. That is not the stand. And this stand is not enough. Kindly see 313 statement. 313 statement on the sentence. This is not only here. Page 64 of the first paper that we had yesterday. And the relevant is at page 77. He is being asked questions under 313. This, so far as the evidence of complaint Purnesh Modi is concerned. Sawal, last but one. વધુમાં તેઓ પોતાની જુબાનીમાં એમ જણાવે છે કે વધુમાં તમો આરોપીએ સદર સભામાં એવો સવાલ કરેલ કે તથા વધુમાં તમોએ એમ જણાવેલ કે પ્રધાનમંત્રી 100% ચોર છે તથા તેઓએ રાફેલ વિમાન સોદામાં 100 કરોડ ચોર્યા છે. પોતાના ચોર દોષ 100 ને તે બાબત તમારે શું કહેવું છે? જવાબ. Now this reply is very important. મને મારા ભાષણના શબ્દો યાદ નથી કારણ કે હું ઘણા બધા ભાષણો કરતો રહું છું, પરંતુ પ્રધાનમંત્રીના ભ્રષ્ટાચારી બાબતે હું બોલેલો. One, very well. The second reply on page 87. When he is asked questions about that so-called miracle witness as stated by the petitioner, that miracle witness question, page 87. સવાલ. વધુમાં તેઓ પોતાની જુબાનીમાં એમ જણાવે છે કે દેશના ચોર લોકોના નામ મોદી 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 એસા હી ક્यों होता है અને એવું કહેલ કે આ મોદી લોકો ચોર હોય છે તે બાબતે તમારે શું કહેવું છે? જવાબ. ખોટી વાત છે. Now my look kindly consider. Here he says ખોટી વાત છે. There he says મને યાદ નથી. What is the credibility of these answers given under 313 of a person who is giving contradictory, different answers and reply? ખોટી વાત છે, મને યાદ નથી. Forgets. So there is, this is the type. I am just indicating it. I don't want to read the entire evidence and everything. Now, my lord, in the context, my lord, kindly see that the conduct of the accused. I am on the conduct. Because when your lordships are granting or refusing discretionary relief. 89(1) uses the word may, and therefore discretion. There cannot be a binding precedent for the exercise of discretion. There can be guidance. We can take guidance from the Supreme Court judgment, other judgments. It's okay. But when the discretion is conferred upon the court, there cannot be a binding precedent. And therefore, my lord, the conduct will be a relevant aspect. As I have submitted, my lord, the about 12 offenses on page 103 of the paper book. And I have, my lord, mentioned all 12, which are defamation offenses only, not other offenses like National Herald or anything, where he is on bail, etc. I'm not touching that. But so far as these 12 offenses are concerned, out of 4 or 5, my lord, cases are settled and complaints are quashed to my knowledge, subject to other side pointing out otherwise. Out of 12. But, my lord, after filing of Surat complaint, at least 2, as per our information as of now, 2 to 3 more complaints are filed under 499. When he used again defamatory utterances against Veer Savarkar at Cambridge, the grandson of Veer Savarkar has filed complaint before Pune court. I have got the status, etc., where that I have produced also in the additional paper book at page 13.
Yes.
Similarly, one such complaint is filed before the Lucknow court. There also it is pending. And these are all happening. These complaints are filed after the complaint filed in Surat case. Kindly see. But page 13 is after conviction, my lord. But Lucknow is not after conviction. Filing date 15th April 23. 15th April 23. And so far as, my lord, that report that I will not apologize, I am so and so, I am not so and so. Your complaint is yet not committed, is per se defamatory. So this conduct is relevant. That it is not that once the conviction is credited in his account, he wants to temper in public utterances. After all, he is leader of a national level political party, which has ruled this country for 40 plus years. And if you just become Mortimer, go on using abusive language for your opponents in politics, then at least you must learn a lesson in your life. That this can't be tolerated by everybody. Therefore, this conduct is relevant. He is not he has not apologized before the commencement of trial. Not even sorry, remorse. I don't say apology in that sense. But very well sorry if you are hurt. Very well I express regret if your feelings are hurt. I never meant that. No explanation. No explanation. And that I want to read, my lord, while awarding sentence, my lord, hearing was given as it is required under the law. And what he has stated, my lord. Page 354 of the main paper. Conviction is recorded, then say hearing on sentence is given, and hearing on sentence, look at the stand and attitude, my lord, I would say. સજા બાબતે સાંભળવામાં આવે પેજ 354. આરોપીને ઉપરોક્ત ગુનાના કામે તકસીરવાન ઠરાવી સજા બાબતે પૂછતા તેઓ જણાવે છે કે તેઓએ જે કોઈ ભાષણ આપેલું તે પ્રજાના હિતમાં મારા ફરજના ભાગરૂપે આપેલ. મારે કોઈ પણ પ્રજા સાથે ભેદભાવ નથી. તેમજ હું મારા દેશની તમામ પ્રજાને ખૂબ પ્રેમ કરું છું અને ચાહું છું. Any politician who has to contest election will say this. Nothing great about it. આરોપીના વિદ્વાન વકીલ દ્વારા રજૂઆત કરવામાં આવેલ છે કે આરોપી દ્વારા કોઈ પણ જ્ઞાતિનું અપમાન કરવાનો ઈરાદો ન હતો. Now that is this is now by lawyer. તેમજ ફરિયાદીને કોઈ પણ પ્રકારની વ્યથા કે નુકસાન થયેલ નથી. તેમજ આરોપીને આ ગુના અગાઉ ક્યારેય કોઈ ગુનાના કામે તકસીરવાન ઠરવામાં આવેલ નથી. તેમજ this is I am emphatically placing into service for my lord's kind consideration. આરોપી પક્ષે કોઈ પણ દયા કે માફી માંગતા નથી. So what option is left for the trial court to exercise the discretion while awarding sentence? If this is your attitude, then my lord kindly see ફરિયાદ પક્ષે I am not on that. Then para 4. સદર કામે ઉપરોક્ત બંને પક્ષોની રજૂઆત તેમજ કેસની હકીકતો તથા આરોપી દ્વારા આવેલ વિવાદિત નિવેદનને ધ્યાને લેતા તેમજ નામના સુપ્રીમ કોર્ટ દ્વારા આરોપીને એલર્ટ રહેવા સૂચન કરવામાં આવેલ છતાં આરોપી દ્વારા તેઓના કંડક્ટમાં કોઈ ફેરફાર હોય તેવું જણાતું નથી. તેમજ આરોપી પોતે સંસદ સભ્ય છે. સાંસદ સભ્ય તરીકે પ્રજાને સંબોધન કરવાની બાબત ખૂબ ગંભીર છે, કારણ કે જ્યારે સાંસદ સભ્યની હેસિયતથી કોઈ વ્યક્તિ પ્રજાને સંબોધન કરતો હોય ત્યારે તેની ખૂબ વ્યાપક અસર પ્રજા પર પડતી હોય છે. તેને કારણસર ગુનાની ગંભીરતા વધુ છે. તેમજ જો આરોપીને સજા ઓછી કરવામાં આવે તો પ્રજામાં ખોટું મેસેજ એટસેટ્રા. These reasons are given, but because the order of the Supreme Court is relevant, Lord, in that matter where he was just cautioned, and that is the order of the Supreme Court. The date on which, my lord, at least the hearing was given to him on sentence, the order was already in existence by the Supreme Court. The argument was that this was before and after. I am not entering it. But the date on which, when you are heard on sentence, the order was already there, passed by the Supreme Court. You know, at page 106, it is quoted.
106 of
The additional paper. That's an additional paper. It is judge. It is part of the reply filed before the sessions court. I am sorry. Here only in additional papers which we have supplied.
that is
I am very sorry for the 106. Only 2 paragraphs I am reading, and
after the reply.
it is reply filed by us
Yes.
after the 313 reply. Yes, I am obliged. Please. Paragraph 29 of the Yashwant Siya versus CBI.
Yes.
29. On arguments having taken place in this context and realizing the seriousness of the matter and the inadequacy of the affidavit, learned counsel for the contemptor took liberty to file an additional affidavit with an order dated 30 April 2019. This court left the admissibility and acceptance of such affidavit to be considered on the subsequent date. An additional affidavit was filed on 8th May 2019, stating that the contemptor held this court in the highest esteem and respect and never intended to interfere with the process of administration of justice. An unconditional apology was tendered by him by stating that the attributions were entirely unintentional, non-willful, and inadvertent. We do believe that person holding such important positions in political spectrum must be more careful as to what should be his campaign line is for a political person to consider. However, this court, for that matter, no court should be dragged into this political discourse, valid or invalid, while attributing aspects of the court which have never been held by the court. Certainly, Mr. Gandhi needs to be more careful in future. However, in view of the subsequent affidavit, better sense having prevailed, we would not like to continue these proceedings further. Thus, close the contempt proceedings with a word of caution for the contemptor to be more careful in future. This is the conduct. This order is passed, my lord, before hearing on sentence. This is what I am submitting. The statement before the Kolar public rally was, prior to this order. I don't say for a moment. But when you were being heard on sentence in 2023, this word of caution was very much there from the highest court of the land. Behave in your utterances. Be careful. You are a senior political leader of the party. Your utterances will have impact. This is all. Beyond that, I am not saying anything. The word of caution was there from the highest court of the land prior to hearing of the sentence. And he says, "Mane, koi maafi maagto nathi, mare ke kehwano nathi. Main koi bhul kari nathi." If this is your attitude, you are well within your rights as an independent citizen of this country or leader to have such attitude. But then you cannot say that, "Sir, I will suffer disqualification, please grant the stay." You are looking meek at that stage. If you are strong, then please remain strong. But if you are not strong, if you cannot withstand this disqualification, making prayer before the court on this ground, then these contradictory stands. Public stand is different, and in the courtroom, the stand is different. And that is where Lordship may kindly scrutinize his conduct, in my respect. Having said about the conduct of the accused, I will be completing within 10 minutes. Kindly see, it is submitted that the judgment in Naran Kacharia, delivered by this Honorable High Court, coordinate bench, declining to stay the conviction under 389(1), is overruled or set aside by the Honorable Supreme Court in the same proceedings which were carried. No, that is not factually correct. Kindly see, if you also have seen me, Lord, I need not waste.
I have seen that.
I am obliged. Then I will not.
It
Was a consent quashing for all
It was
purposes.
only on a ground of compromise.
Grateful.
And
Therefore,
5 lakh rupees they have
therefore-
paid, therefore they have said.
obliged. That is all that I wanted to submit.
I have
If it
seen
is
that.
present in my Lord's mind, I did not take your Lordship's precious time
Yes,
on
I
that
have seen
point.
that.
But therefore, the law laid down in Kacharia, I am placing into service, which is so far not
In fact,
overruled,
the observation made by the so honorable court
Yes.
is confirmed by the honorable
Is-
apex court.
is confirmed, at least if not set aside at
Not
any
set
rate.
aside.
Now, therefore, where there also a public figure was there,
Yes,
and the court said they know nothing doing. What is this? If you commit such offense, though you are acquitted from a serious offense of atrocity, I will not protect, I will suspend the sentence,
yes.
but I will not give you license to continue because of my order.
Supreme Court order emanating.
I have annexed both the orders, bro.
I have
If you
seen.
look at pages, then I will.
Even from their
Yes.
compilation, it is there.
Lord, in fact, we are not raising this at all. Let me be clear.
No,
We are
Mr.
only
Singh,
raising- Just a minute.
I'm sorry.
What we are emphasizing there is, Lord, when the Lordship of the Supreme Court passed the order, they have said that the right of the electorate in a by-election, it is only that part.
No, in fact, Mr. Dr. Singhvi has raised these serious that Naran Kacharia judgment is already overruled by the honorable apex court.
Let Lord know that I am
Yes.
that is the part, Lord, Lord, had the occasion to submit it there. That is the part. The overruling is not in that sense. It is in this sense that when we say irreparable loss and irreparable injury, the apex court has noted in the judgment, Lord, that other part. So we would, if there is any impression on
Yes.
there's no contradiction as such. The
Yes.
only part we are highlighting is that the electorate of the constituency to which not that particular person belongs, they also have an interest in the matter. That's the only part. So let's show that my lord not have to bother about that. We are not relying
Yes.
on that in the sense that all these conditions that changed, we have apologized, he was asked to pay fine, he had paid the fine. The only relevant part for our purpose is that
Wills.
It's fine.
Yes.
Since the stand was taken earlier different, therefore I submitted this. Anyway, if that is the stand, I have nothing more to say. The stand was that it is set aside virtually and not approved by the Supreme. Below, I have annexed the judgment which is on judgment compilation page 12, paragraph 20 to 26 are relevant paragraphs of my Lord Justice Shukla's judgment in Narang
Yes.
Kachari. Now, my Lord, kindly see, all submissions were made. All submissions were made. Each and every submission, my Lord, I am not picking up and submitting reply. But the relevant is that except reading few paragraphs from the judgment of the appellate court, I am at least, I could not gather that on what grounds the judgment is being challenged. This is not the first application before the Honorable Court, High Court, under 389(1). It is already adjudicated by the competent appellate court. You are aggrieved by that order. Very well, you can file this proceeding. I am not saying anything. But then you will have to point out some infirmity, some error, factual or legal, committed by the appellate court. That is not done in my respectful submission. Once that is not done, this is not a first application coming for the first time before the High Court, and High Court has to consider. The validity of conviction also, my Lord, is not the subject matter of this proceeding. It is sub judice before the appellate court. So that will be considered. One more point about 202 is also raised, that prior lacuna is pointed out. But I am placing into service section 465 of the Criminal Procedure Code, 1 and subsection 1 and 2 both, that at the threshold, right till the conviction is recorded, you have never raised this contention before any forum, including the same court or other superior court. And therefore, trial cannot be considered as vitiated. In that line of the matter, even that, my Lord, substantial compliance is already there as per the judgment of 202. Very 465, my Lord. Subsection 2, my Lord, kindly see more particularly. I will read only 4 lines. Nothing. 465 subsection. In determine, I'm sorry.
Yes.
In determining whether any error, omission, or irregularity in any proceeding under this code, or any error or irregularity in sanction for the prosecution as occasioned a failure of justice, the court shall have regard to the fact whether objection could and should have been raised at an earlier stage in the proceedings. Note subsection 1 says that.
Yes, that the first part is.
Yes. So, my Lord, it is burdening us is on them to show that why they could not take objection at the threshold about 202. In my submission, my Lord, 202 is substantially complied with. My Lord. In the alternative, I am making this submission, my Lord.
Yes.
So this is on that 202. Whether I am aggrieved person or not, may not per se I am aggrieved. You leave aside the class and 13 crore and all that. I am Purnesh Modi, and you have said all Modis why they are thief.
Yes.
I am not in filing for 13 crore, my Lord. I am at least I am humiliated, insulted, and defamed. So 199, I am aggrieved person.
In persona.
In person.
Yes.
So if I am, aggrieved person, that submission also is not well taken in my humble submission. That I cannot file for all and daily and all that. That is not relevant. though it must have been discussed. But for this application, at least, if I don't have Modi's surname, stands on a different foot. I have placed material on record, which is considered by the trial court in the appellate court, that yes, I am Modi. I have changed my surname years back, decades back. And therefore, I am not bothering by reading that document. But otherwise, it is at page 80. New compilation, it is there. Exhibit 39, yes. That is resolution passed by the government of Gujarat. That is page 39 of the additional paper. Nothing 39, it's different. Which paper? Page 25, exhibit 39, I'm sorry. Yes. So this is a community. And I have stated in my evidence that after following due process and procedure, my name from so and so is changed to Modi. It has come. So I am an aggrieved person. That is all the endeavor is. And that contention is also not raised in any proceeding so far till the conviction is recorded. That I have no locus standi. I am not an aggrieved person. You never said so. Such contentions, assuming that they are available without admitting, then they are required to be taken at the initial, very initial stage when the complaint is filed. You could have invoked 482 or whatever as advised proceeding. That not complaint is not tenable, not maintainable. No such contention is there. Much emphasis was laid on moral turpitude. Moral turpitude is undefined, is not defined by any law. In 2010, volume 8, Supreme Court cases 573. Paragraph 23 and 24. I am placing it to service. Please. Moral turpitude means per Black's Law Dictionary 8th edition. Conduct that is contrary to justice, honesty, or morality in the area of legal ethics, offenses involving moral turpitude, such a fraud or breach of trust, also termed moral depravity. Moral turpitude means in general shameful, wickedness so extreme, a departure from ordinary standards of honest, good morals, justice, or ethics, as to be shocking to the moral sense of the community. And when you say that all Modis are thief, is it not, I am putting it to myself, moral turpitude? Coincidentally, the surname of the Prime Minister of this country is also Modi. What message you are going by giving by these utterances to the world, that the opposition leader of India brands his Prime Minister as thief in public rally attended by thousands of people? Is this the language? Only on the next page, 581, yes, in the quoted paragraph, which is quoted from Baleshwar Singh versus District Magistrate, 5 lines. it is discloses willness or depravity in the doing of any private and social duty which a person owes to his fellow men or to the society in general. If, therefore, individual charged with certain conduct owes a duty either to another individual or to the society in general to act in a specific manner or not to act, and he still acts contrary to it and does so knowingly, his conduct must be held to be due to vileness and depravity. It will be contrary to accepted customary rule and duty between man and man. And this is where the moral turpitude is, if at all. Prime office. Seriousness of offense. Offense is not involving moral turpitude. It has no societal ramification at all. These were the submissions below. I am with great respect submitting that it is serious. Parliament says it is serious. It is moral turpitude because of this. And therefore, such an offender cannot be considered. His application cannot be considered, I'm sorry, for stay of conviction in my respectful submission, whatever be the consequences. They are not, my lord, that consequences by which something great damage is going to be caused. He has said that whether I am in the house or not, this is what your public stand is. Whether I am disqualified forever, I will continue this. Very, very. So in my humble submission, the application deserves to be rejected, and it is without any merit. And Lordship may kindly reject the present petition itself, Lord. Some written, my friend has prepared some written submissions. I will give the copy to the other side of the place in my Lord's permission. I am obliged for the patient here.
Yes, Mr. PP, what do you have to say?
Sorry.
PP.
Just in addition to what I submitted the last
Yes.
and already said necessary for seriousness of the offenses. One more aspect with regard to seriousness would be for honorable court's consideration. Who is the offender? And as to who is the offending person? Now, offender himself, as per the submission of the legislature advocate, is a legislature. Their function is to evolve law, to legislate the law, and they themselves, I mean the petitioner himself, is breaking the law. Now, that is one more element to assess the seriousness over and above what my learned suggested. The offending class is a group of persons. So both together, offender and offending class, makes the case more serious, more particularly when petitioner is placing this case before the honorable court, that he is a legislature. Their function is to legislate. They themselves are now breaking all other aspects of my legislation.
One thing I missed, if I permit,
Yes.
1 minute only.
Yes.
I'm very sorry for that. You know, in the today's paper book which I have supplied, page 2, you also may kindly see. You know, after Lily Thomas judgment, you know, the bill was moved before the parliament. Reenacting subsection 4 of section 8 of the representation of people. The proposed amendment was this. Notwithstanding anything contained in subsection 1, 2, or 3, a disqualification under any of the said sections shall not, in the case of person who on the date of conviction is a member of parliament or of the state legislature of the legislature of the state take effect. If an appeal or application or revision is filed in respect of conviction and sentence within a period of 90 days from the date of the conviction, and such conviction or sentence is stayed by the court. Provided that after the date of conviction and until the date on which the conviction is set aside by the court, the member shall neither be entitled to vote nor draw salary or allowances, but may continue to take part in the proceedings of parliament and legislature of state, as the case may be. This is of 2013. The party of which the petitioner is leader was in power at the relevant time. When this bill was circulated, the present applicant himself, the newspaper reports are, I am not placing them into service because they are newspaper reports. But the report says that he torn off this bill. That what is this? I want purity of parliament. That is the legislative history of this. This bill has not passed. It was not moved at all thereafter. But it was not moved because the present applicant objected to it. This is all that I am facing. Otherwise, it would have provided relief to him today. I am obliged.
Yes. Yes, doctor.
Or I wonder whether it's my timing which is impeccable, or my friend's timing which is impeccable. He appears to have completed just when I arrived. I'm grateful for the accommodation. I'm sorry, Manoj, I couldn't come a little earlier, but there has been no loss of time. I seem to be exactly on time. Now, Manoj, let me go one by one. And we've had a system which has largely apprised me of what has been happening. Some other leftover points my learned friends here will cover in addition. Let us just step back for a minute. I'm going to make pointed points for us and rejoinder. Let's just step back. What are we today here in? What is your lordship dealing with? Your lordship is dealing with 389. So my first question to myself, is there a section called 389? Obviously there is. Second question to myself, what is that section inserted for? For what purpose? To give a suspension of a certain act, conviction, etc., etc. What is the purpose of that section? The purpose of that section is, and can only be one, sole, that in cases where the conviction has a deleterious, serious, adverse consequence, why should your lordships, in the fitness of things, if your lordship so finds, not have the power to suspend it? That clearly is the object. Question number 4 to myself. Does 389 make difference, or does it make segmentation, or does it make categorization of the kind of offenses? Answer is clearly no. 389 is not offense specific. In other words, 389 cuts across the entirety. So it is wrong to suppose that there are certain offenses which are outside the purview of 389 or beyond the pale of 389 or somehow not contemplated as suspendable convictions or suspendable sentences. That very assumption is wrong. And the last question to myself is, how is then 389 operated? Not by looking at an Act 8.3, not by looking at some section. It is operated by seeing certain parameters which my Lord has laid down. My Lord means the jurisprudence has laid down. That what are extraordinary circumstances? What are serious offenses? How, when, what, for what reasons, for what criteria would you suspend and would you not suspend? So that's my point number 1. Therefore, that's the first point. There is a section created clearly for suspension. The purpose and the rationale, the raison d'etre for that section is to give relief to a person accused of a certain crime so that the deleterious consequences of that crime are mitigated. And then it is not that certain things are put in a schedule under that section which are untouchable. No. And it is not, it is section neutral, it is offense neutral. That's my first point. My second point is that the courts actually have given us enough guidance as to when, how, and for what reasons will your lordship suspend. So the test is extraordinary circumstances. Now clearly there is no section which says in this act, section 2 bracket E, extraordinary circumstances are defined as so and so. That's not the way it works. Extraordinary circumstances, fortunately, your lordship has made reasonably clear in the jurisprudence and the judgments. And this is the fundamental error of the submissions of the respondents in this appeal, because they assume or think that there is an exclusionary element in 389 which is untouchable. And they take the word serious to be a self-serving phrase, that what the complainant calls serious or thinks serious is serious. So, what is that jurisprudence on extraordinary circumstances? It's a very interesting and a simple one. Shyam Narayan Pandey educates us in the negative. What Shyam Narayan Pandey, which I'll be showing in a minute, does is, it educates us in the negative. It doesn't say what is the extraordinary circumstances by which your lordship may give. It tells your lordships on a principle of exclusion as to what are the circumstances, a few of them, where your lordships would not normally give. Even there your lordships can give, but would not normally give. So it does on a principle of exclusion. And it says so by showing that certain things would not be called an extraordinary circumstance to grant a suspension. By obvious interpretation, all other cases are fit. Now there are two categorizations there. The categorization is not only on seriousness. One is what is perceived as serious, and there is law on that. The other is even if not serious, by way of length of punishment, etc., where it is moral turpitude based. Now let us kindly see the examples where it is thought that your lordships may not have extraordinary circumstances. But remember that the caveat is very clear. Even there your lordships can give, have given in any number of cases. But your lordship will be hesitant to give. And this is very, very important. What is that, Willis? There is one death sentence. I'm being very specific. This is the case law. Second, life imprisonment. Third, imprisonment above 10 years or 10 years and more. Fourth, now these are serious. These are categorizations which are long and serious. There may be some offenses which are not so serious in terms of length, but they are considered serious in terms of moral turpitude. Namely, Prevention of Corruption Act. Now, in these cases, none of these cases, not one of them says that electoral disqualification is a serious offense, unless the disqualification is for one of these, murder, death, life imprisonment. So it's extraordinary that my learned friends are laboring and applying this to a principle of defamation, which is remarkable for the reason that defamation is nowhere in this list of any case which is considered, forget granting or not granting conviction suspension, forget granting or not granting etc. Not one of the cases suggests that defamation is the category of either serious or it is the category of moral turpitude offenses. Then I am asking myself, on what distorted principle are you, apart from a certain amount of dislike for the person concerned, you denying this? Then Malas, just note, defamation actually on every test falls in the opposite category. It falls in the spectrum, which is the direct polar opposite. And therefore it is most sad that it is being treated as a offense which is unpardonable, which is a serious crime. Number one, why? Well, why? And not on one, some things fall in the opposite spectrum on 1 point or 2 points. Here, Malas, it is a very remarkable convergence cumulatively of all the tests. For example, one obvious test is it bailable? Number is, how many offences does my Lord consider bailable which are serious? What is the very meaning of the word bailable, Malas? I'm asking myself.
That you have
Second-
pointed out, perhaps 26 is the offense bailable, otherwise all are 26 or 27 offense.
No, that is the second point. No,
Second.
my Lord is right. That is the first point is not that. First point is simply bail. Well, forget everything else. Suppose your Lordship says bailable. Bailable broadly, subject to something means that a police can grant bail. Normally, Malas, it will never be serious if he can grant bail to me. I don't have to come to a judicial level. Normally. Second, as my Lord just said, rightly, some 22 actually we have counted, 24, 22, where it is simple imprisonment. This is a very select category, Malas. Obviously, the statute, the legislature thought it fit to put it in a category which is less serious. There's no question of us having a, if I may call it the word, it's a wrong word, a very interesting word, mandatory simple imprisonment only. Can't go beyond that. Third, nobody has suggested any jurisprudence that it's an anti-societal offense. It is anti-societal. Nobody. That's the third test. Fourth is it is non-cognizable. Now, Malas, how many cases does your Lordship have where all the four intersect? Your Lordship has some, not all. All four intersect. And your Lordship is told it is such a heinous, serious offense that your Lordships can't consider 389. So, Malas, without going into 10 years, without going into life imprisonment, without going into the case law, I would say the per se category of defamation, which has a convergence of these four things, per se makes it the simplest offense, Malas. And if 389 is not created to suspend that conviction, then it might as well be repealed. 389 will not find a simpler conviction to suspend than defamation, which is non-cognizable, which is simple imprisonment, which is bailable, which is anti-society, which is not anti-societal. Therefore, Malas, my learned friend's suggestion, which I am told Malas he made today also, that because it is put in 8.3 and because there is an 8.3 disqualification, therefore it is more serious. No, on the contrary, Malas, that is a ground of irreversibility, which I am now turning to, Malas. Malas, these four tests are broadly, Malas, noted in Subramaniam Swami's case. Your Lordship will note the citation which is there, Malas. It's in our compilation at
You
page
have
1.
provided this, his first compilation.
First case. Malas, para 176 notes these four characteristics.
Para?
176. Just check out. That is non. And your Lordship will note the second case, Malas, Shyam Narayan Pandey,
Yes, that
which
will
is
be
in your Lordship's compilation at page 135. In that Shyam Narayan para 6 and Subramanian Swami 176, especially Shyam Narayan, these four intersecting elements of this offense are noted. And therefore, Malas, I submit that if there is a classic offense, which is the mildest form of offense, which must lead to a 389 suspension, then Malas, it is this. The third aspect is, Malas, and that I argued at some length last time, is irreversibility. Well, actually, 389 is a simple test. Your Lordship is not deciding whether I am guilty or innocent. That the trial court will decide or the sessions court will decide. But Malas, your Lordship is doing what your Lordship does in every case, criminal or civil. Kind of a lose, as I said last time, wrong word to use in criminal law, but still it's the same thing, balance of convenience. That is this problem, is this hurt, is this prejudice irreversible? Every case, Malas, because your Lordship cannot do the final and the interim at the same go, involves a certain interim, Malas, decision and call to be taken by the learned judge. That call is based on, Malas, irreparable loss or irreversible nature of the injury. Now, Malas, before I come to a couple of cases, or mainly one case, Malas, two paras, I want to ask myself, so I've done with the first part of the simple. I'm now on the, that's the nature of the offense. Now I'm asking myself, can there be something more irreversible than a disqualification which robs you of a status as a parliamentarian or an MLA? So forget this case, fellows. Ask yourself the question conceptually. As I tell you, there are two kinds of persons, let us assume, who commit the offense of defamation. I am a member of parliament, he's a non-member of parliament, both of us commit. Well, it's the member of parliament in that sense has greater irreversible prejudice in that sense than the non-member of parliament because he loses his seat. That's a point in my favor, not against me. My learned friends, brothers, have completely misunderstood the point in my favor and are projecting it as a point against me. The loss occasioned to both of us is bad. Because he loses mental peace, he loses so many things. I lose all of that. But one additional thing I lose is probably the most irreversible. There is no answer to that. I argued it partly in the opening. There's no answer to that. There cannot be an answer to that. An infant can't invent an answer. Well, I have already a certain portion of my last session. I have already my role as a parliamentarian in committees. Well, as parliamentarians or MLA, same thing, function both inside parliament and outside. So when parliament is session is not the only test. There are parliamentary committees, there are parliamentary papers, there are parliamentary interjections. They happen in committee meetings also outside of the session of parliament. Now, when it's the last part of the last session, he loses. Many committee meetings he loses. And the immediate next session he will lose in case he doesn't get a suspension. But that is his loss as a parliamentarian. Here again, there is an intersecting triple loss. There is a loss to him, naturally. He is there in public life to project the voice of a certain section of people. He loses that right. That's a great loss to him. And incidentally, I've had the privilege of being a chairman of many parliamentary committees. What your lordship sees in these cameras, real solid work is done in parliamentary committees. They say, parliament at work is parliament in committee. Parliament in committee is parliament at work. A far greater degree of unanimity and convergence happens in parliamentary committees than what your lordship sees on the cameras in inside the House of Parliament. In fact, there were a couple of proposals some years ago, when they've introduced cameras for parliament, that you should have cameras for committee meetings also. Whereas I personally vehemently opposed it, so many others opposed it, that whatever little good consensual work is being done, you don't want it to be lost by the glare of cameras. So a lot of work outside of parliamentary session is also lost to parliament. That's one loss. Second loss is to the people of his constituency. They have an elected representative, Mr. X. He may be good, bad, or indifferent. It's their choice. It's not my choice, it's their choice. Their choice loses its voice. Their choice loses their voice. These are not mere empty rhetoric. These are practical. In a democracy, the lordship knows we live by fictions. When a decision is taken by 700, 800 people in parliament, it need not be that everybody who is elected them agrees with it. But the fiction is that you are elected and therefore you have the right to enact a law which is deemed to be their will. They are the electorate. So in the same way, on that fiction, that entire right of that collectivity known as we the people is lost. The third loss is, the third loss is to the nation, because ultimately what is the collectivity across, so one is personal, one is constituency, the third is to the entire collectivity of parliamentary democracy, because parliamentary democracy is made of a collection of those constituencies. Therefore, your lordship would have to consider, can any of these be reversed? We are on reversibility, balance of convenience. I gave lordship two simple examples. Assume, now example number one is that what is already lost, we are now arguing on 2nd or something of May. So what is lost from the date till now is lost. It is I can't think of any way in which your lordship can restore it. I mean, a court is only human. A court is not supernatural that can restore. How can a lordship restore it? Nobody can restore it. There's another thing. Suppose this lingers on even for a day. I mean, day means any small length of time. The Election Commission is absolutely under no obligation that Mr. Singhvi is arguing here and Mr. Nanavati is arguing there, and there is something going on there. They say that this constituency will not go unrepresented. As I told you last time, that limit of time can be as little as 3 months. It can extend sometimes to 5-6 months. Well, if the election is declared, and after that, well, there's another thing which happens. Once an election is declared, the normal window is about 6 weeks. The moment that notification declaring a by-election, not even election, a by-election comes, your lordship knows everything stops. Your lordship doesn't interfere on that old fiction that now you challenge after the election. Your lordship. So the entirety of that thing can't be stopped. Thereafter, Mr. Rawal is elected. Can I come and say, please unseat Rawal because your lordship were hearing my matter? Can anybody say that? Or your lordship says, now there's a third example. I've given a third example. Your lordships in the course of either before Mr. Rawal is elected or 3 months after he is elected, the primary sessions court acquits me. It's very easy. Tough luck, Mr. Singhvi, go and fight an election again.
Yes.
To make that balance, your lordship has a provision for stay of conviction. It is for that reason alone. Then there is a outer fourth facet, the cost on the exchequer of the election. Look at the concentric circles your lordship has. Personal core, collectivity constituency, larger collectivities of parliamentary democracy, and then the cost to the exchequer of having an election actually with a man already elected who has not completed his tenure, but who is subject to litigation, where he is arguing 389. This is a classic case. That is the real test. All this thing while elephant is telling a lordship about how serious it is, or the evidence is only to satisfy lordship's conscience. Ultimately, the lordship test is only this. Now, in that light, just see 2 paras of a judgment called State of Rajasthan versus Salim Khan, 2015. Just para 21 and 22. 2015, volume 15 SCC, 666.
Which para you are referring?
Para 21 and 22. No, for the court. May I read 21?
Yes.
Page 7.
If some foreign country is not granting permission to visit the country on the ground that the respondent has been convicted of an offence and has been sentenced for 5 years of imprisonment under the Indian law, the said order cannot be a ground to stay the order of conviction. If an order of conviction in any manner is causing irreversible consequence of injustice to the respondent, it was open to the court to consider the same. Mark this line. Irreversibility will vary. Your lordship is the judge of irreversibility. If the court comes to a definite conclusion that irreversible consequences and injustice would be caused to the accused, which could not be restored, it was well within the domain of the court to stay the conviction. No such ground has been shown by the High Court while passing the impugned order. Further, we find that now more than 1 year has passed and there is nothing to record that the respondent has to visit the UK again. That's for shooting of a film. That's the facts of that case. For the reasons aforesaid, we set aside the impugned judgment passed by the High Court of Rajasthan and Jodhpur, Salman Khan, etc. Remit the case to the High Court to decide the matter afresh. We open to the respondent to show that if the order of conviction is not stayed, it will cause irreversible consequence injustice to him, which cannot be undone if he ultimately succeeds. We open to the state to oppose each prayer. But I am saying these are actually much weaker cases compared to mine. Ex hypothesi, the nature of the post I hold is such that the consequence is completely irreversible. Ex hypothesi. It is something which doesn't need to be stated. It cannot possibly be restored. Now let us kindly see Navjot Singh Sidhu, para 20 to 23. Now remember, this was a murder charge.
Last last order of Supreme Court under which he has to undergo conviction and he has to remain in jail.
Now,
for
I had the
one-
privilege of arguing that for him, that 1 year thing. But when the matter started,
Yes.
this was a case of, my
304
learned friend was there also.
Was by case, Lord, when he acquitted, review Mr. Singh Vida.
It started with what is the 302 charge. The charge basically, let's forget what is 302, 304. I'm asking myself, am I anywhere near 302, 304, and 30? Am I anywhere near that? I'm in a different world
And
as far as those sections are concerned.
subsection 4 was live when Navjot Singh resigned, which was subsequently declared otherwise.
Yes, yes.
So that-
No,
But then he
no.
offered to resign. That's all that happened.
Kindly see what is para 20 onwards. I am now not on that. The law is now what is very clear in 83 and 389. Now we are on what is the point that it is wrong to think that the moment you are convicted, Parliament becomes a barred area for you. That's not the approach. Under controlled conditions, you are still entitled to be in Parliament. That controlled condition now is suspension. It was suspension then also, but there was an automatic continuance given, which law was changed. It is not that your lordships has well as a completely barring effect. That's what I'm reading. Mr. Dwivedi, for the complainant, I'm reading para 20 verse,
Yes.
has submitted that in order to maintain purity and probity in public, this was the argument which was rejected. Probity in public bodies, criminalization of politics has to be stopped, and persons who have been convicted of any offense should not be allowed to enter Parliament. Now, this is actually the approach which has to be seen. He has elaborated his argument by submitting that irrespective of quantum of sentence, if a person is convicted for an offense referred to in 8.1, where the punishment imposed may be only a fine. That's exactly the point I'm arguing. A simple imprisonment, small punishment. Even then, Mr. Dwivedi says, no, doesn't matter. Out, you're out. A person will incur the disqualification from the date of conviction, which will remain for a period of 6 years. And this evinces the intention of the legislature that convict should not enter the precincts of Parliament or legislature. I'm on this narrow issue. I'm not arguing the current issue. I am saying the precise argument was raised twofold. One, please don't look at moral turpitude and seriousness. Any offense and zero tolerance, you can't enter Parliament till you get an acquittal or you're out completely. That was the argument. In our opinion, the contention raised cannot be accepted. The preamble to the Representation of People's Act of 1951 is quoted, and just see that one is an act to provide for the conduct of elections to the Houses of Parliament, to the Houses of Legislature, qualification and disqualification of membership, corrupt practices, other offences, etc. The Act provides not only the eligibility and qualification for membership of the House of People and Legislative Assembly, but also for disqualification on conviction and other matters. Parliament in its wisdom having made a specific provision for disqualification on conviction by enacting 8, it is not for the court to abridge or expand the same. The decisions of this court rendered in Ramanarang and Ravikant Patil. Now, my lordship, remember when I opened it, I gave a lordship these
Yes.
judgments, and I gave the pages in the test also. Having recognized the power possessed by the Court of Appeal to suspend or stay an order of the conviction, and having also laid down the parameters for exercise of such power, not possible to hold as a matter of rule or to lay down, not possible to hold as a matter of rule or to lay down, that in order to prevent any person who has committed an offence from entering Parliament or the Assembly, the order of conviction should not be suspended. The courts have to interpret the law as it stands and not on considerations. Your lordship is really being argued today by the other side as if this is some kind of a heinous situation where the moment I'm convicted, you can't touch it, he can't enter Parliament. The whole law of suspension is made only so that he can enter Parliament. So that all these 4 tests of personal laws, constituency laws, parliamentary democracy, and cost to exchequer are balanced depending on the context of a case. Shri Dwivedi has also submitted that once an accused has been convicted, it is only the execution of the sentence which can be suspended, and the order of conviction cannot be suspended or stayed. This is one of, again, now your lordship is hearing conviction stay because it's been settled by the Supreme. Otherwise, the argument was you can't stay conviction. You can stay sentence, so what? Now see how it's answered. Go down 5 lines in para 22. The contention is that the appellant would not be absolved of the disqualification even if an order of suspension or stay of the conviction is passed by this court. We are dealing here with the limited question, the prayer made by the appellant for suspending or staying the order of conviction. We are not required to adjudicate upon the question as to what will be the effect of the order, and further whether he will continue to be disqualified for the purpose of contesting the election, even if the prayer made by the appellant is granted, as such an issue is wholly alien to the present controversy, which can arise only in an election petition where the validity of the election may be called in question. Nonetheless, whether he can fight an election in a particular election petition, what ground somebody will take, I don't understand why anybody should agonize on that. Then, well, it's the very last part of para 23, because Mr. Dwivedi made a third submission. Just see the last 5 lines of para 23. It would be a sublime public policy that the convicted person is kept under disability of conviction instead of keeping the sentence of imprisonment in abeyance till disposal of the appeal. In such cases, it is obvious to be highly improper to suspend the order of conviction of a public servant, which would enable him to occupy the same office which he has misused. This is another point, Wallace. Suppose, Wallace, I am convicted of an offense which involves the very chair which will be activated if your lordship stays. Well, I can't think of it. Suppose, Wallace, I mean, the offense involves, Wallace, something very unruly or slapping a servant while I am sitting inside Parliament on a particular chair. Your lordship may have a consideration that reinstating me in Parliament will, Wallace, activate that very offense again. That is not the case here, is what the court is saying. Certainly, it is not the case in my case at all, Wallace. Cannot be the case. Namely, your lordship's stay of conviction enables me or puts me in a position potentially to repeat the offense. Now, let's kindly just look at a few other things. There is no, let's, prima facie finding of relevance. I will call it as relevant prima facie. There are findings. Relevant prima facie finding, which will disentitle me to stay of conviction as far as the Sessions Court is concerned, and hardly any in the trial court. I'll give you an example straight away. What appears to have weighed in writing in the Sessions Court, and your lordship saw it with me last time, your lordship knows the pages, is A, that the derogatory remarks are made against a personage as high as the Honorable Prime Minister. I entirely agree. That would be a relevant consideration provided any of the persons named had been a complainant. Nobody is denying that the position is very high and sovereign, but we are not concerned with that complaint. So that consideration, how is it found place in the Sessions Court? I don't know. It appears that it's been colored by that. And that is an irrelevant consideration. With the greatest respect, that's an irrelevant consideration. Yes. Since there is a direct bar, I cannot proxy prosecute. There is no proxy prosecutor, I prosecute for him. The whole reason of this 13 crore business, I argued at great length last time, I don't want to repeat it, is because he is not prosecuting, the complainant is not the person named in that statement. That's why this 13 crore business, one in the class, one person in the class is brought in. That's consideration number 1 in the Sessions Court. Second consideration is that because the accused, me, is a public servant, I need to be dealt with more sternly. This is found in both the courts. With great respect, that is very unfair. I gave a simple example. Forget this case again. Take a case where Mr. Rawal commits an offense and Mr. Singhvi commits an offense. If you're identical, you're not supposed to assume it is identical. But if Mr. Rawal's act, not offense, Mr. Rawal's act is not an offense, then Mr. Singhvi's act cannot be an offense, merely because Mr. Singhvi is a public servant. I hope I'm clear. It is the act which has to be an offense, not because Mr. Singhvi is occupied. I understand, Malas. If your lordship finds Mr. Singhvi guilty then your lordship may give us little more punishment because he is holding some position as a public servant. But that can't be the test, fellows. Liable to be dealt with more sternly. There is no question, fellows, that if it is, you have to see individually whether a statement where no named person is a complainant is liable to criminal defamation because you are one amongst a class of 13 crores. That's a legal issue. It doesn't matter how high the person is, and it doesn't matter whether the accused happens to be a public servant or not. The third is that a speech given during a campaign stands on a different footing. Well, look at the errors. It's writ large, the error. As a matter of fact, your lordship gives a little more license. The lordship sees the kind of things being said. I don't support most of them this way or that way. But in the heat of the moment in a campaign, 19(1)(a) acquires a fuller bloom, not a lesser bloom. Well, it's not a wilting flower. It's, if at all, a more blooming flower. Well, the impugned order seems to think that people will be more subdued during the course of an election campaign. It's just the opposite is true, Malas. If there is a free speech right, nobody is saying that because I'm giving election speech, I can violate defamation law. That's not the point. I'm giving the one by one reasons given by the learned judge. Reason number 1 is wrong. Reason number 2, I'm now on reason number 3. Reason number 3 is there a speech given during the course of election campaign on a different footing. No. You have to individually judge, as I said, same test, whether his statement is defamation. If it is, then whether it is given in a speech or not, it's equally culpable. But if it is not, the fact that Rawal said it in a speech will not make it more culpable, Malas. Then, Malas, the fourth reason is related. The complainant, being an ex-minister involved in public life, certainly suffered harm in his reputation. That's the fourth reason given at page 69. The lordship has seen these reasons. Now, Maharaj, actually, again, the opposite is true. Of course, apart from the thing which the lordship has said repeatedly, one of the greatest qualities when you're in public life is to be thick-skinned, not thin-skinned. Thick skin is a great attribute and a great virtue in public life. Nobody, Malas, has the business of being oversensitive and say that I have been in public life, I'm an ex-minister, but I'm so sensitive that the moment somebody sneezes, I feel. Here, Malas, this person is aggrieved and hurt because he's 1 out of 13 crore people, is what he says. But that apart, yes. Yes. And Malas, therefore, this whole approach that he, Malas, being an ex-minister involved in public life, should be in that sense slightly more protected. Just the opposite is true. As they say, if you go into public life, you are submitting yourself, as they say, to the brickbats of public life, and you must have a little more thick skin. The fifth error in the same page, same sentence, 69, same page, is Malas speculation. Pure speculative findings, pure hypothetical findings. And one sentence makes it clear, Malas. Such defamatory remarks, he's talking about the complainant, Malas, the ex-minister. Such defamatory remarks, I'm reading word to word, would have certainly harmed his reputation and caused him pain and agony in society. That's not the test at all. The test is not to find that man who's the weakest link in the chain, who's hypersensitive, and say, look, all these people here would not be harmed. But that one man at the end of the room is so hypersensitive, he might have been, he would have been. And therefore, I will apply the law of defamation, qua his test. Because would have been harmed means, what is he harmed? What is he shown? He's only got one sentence case. My name is so-and-so, I'm a class of 13 crore, I am also defamed. At the end of the day, that's the whole case. That, Malas, is a purely speculative, hypothetical, incomplete kind of an allegation. Forget the proof. Then I made my point about identifiable class. I'm not going to repeat that. I've given out the case law. That is the single most jurisdictional important point in this case. Jurisdictionally, Malas, the whole law of defamation was never intended. I made it in great detail last time. I'm in the jointer. I'm not repeating. Your lordship is being asked to do violence to the concept of an identity. How can a class of 13 crores be an identifiable class? by very definition. We've argued all the names. I've read the evidence to your lordship. I mean, that would be really repetition. But this is directly the heart of the matter. Law says directly, Subramaniam Swami says directly, identifiable class, para 176. I read it to your lordship. Now, any application of that in any which way, as a matter of fact, your lordship has got smaller classes. This is the first case I am coming across where the class is defined as 13 crore people.
Question not answered it on this one. It can't take in its embrace.
My learned friend, I read the written submissions last time. My learned friend argued in the sessions court. I read the written submissions. Written submissions specifically make this point. He orally argued it. The judge notes it. The learned judge notes it. There's no answer. There's no answer. If this is correct, then there is a jurisdictional error. So, I defame him by name, he doesn't file. He files saying that by defaming him by name, I'm defaming the entire class of people standing here. That's the whole thing.
In the order, it's not answered.
It is noted in particular in para small Roman 3 at page 67 of the learned sessions court order. In the revision 5. In the revision 5. I did read it last time, and I'll just remind again. Yes. This I told you also last time again, but I'll repeat it again. This is an important point because point taken, point noted, but not answered.
Yes.
I'm only
That
on
you
another.
have last occasion you have pointed.
I am grateful.
67,
No,
68,
I'm
69.
I'm
all
grateful.
this.
I'm grateful. I raise it. You can reject it. You can say it is wrong because of 1, 2, 3. You've not dealt with it. I can't show negative. Where have you dealt with it? You've not dealt with it. Then, Malats, the learned appellate court has suddenly relied entirely on this magic witness, which I told you last time, is this Yaji. And my learned friends say that he was the only virtue he has is he was present. Your lordship noted me last time at great length. I dealt with Yaji. I showed you the pages also.
Yes.
But just to remind lordship, two very simple things on Yaji. Whereas Yaji, your lordship will note, is a person who suddenly appears like a magic wand 2.25 years after the complaint. Point 1. Point 2, he is not in any list of witnesses. Point 3, he starts his deposition, and your lordship saw with me page 44 to 46 of the compilation last time. I'm grateful. I'm grateful. He starts by saying, I'm a very strong pillar of the BJP. I have been for 40 years with the BJP, 45. I am now the cultural advisor to the Karnataka government. I have worked with the complainant in this position. I have done so many posts. A man, Manoj, with that background appearing 2.5 years later, suddenly, without being in the list of witnesses, Manoj, it's very easy to make a frame of conviction on that. Now, this all I showed to your lordships, the written submissions, page 666. Page 666, written submissions. Directly the point, same thing, taken again by my learned friend Mr. Chima, not answered, not dealt with. But Manoj, the learned court fully relies on Yaji, doesn't deal with any criticism of Yaji. As a matter of fact, Manoj, everything else comes down to Yaji, boils down to Yaji because
He has said only Yaji. He says electronic.
Now, Manoj,
Today.
the answer here, just see the irony, Manoj. There is a whole host of witnesses. They are named in the beginning. None of them is found of any relevance. Most of them have not been there, they are not seen. Yaji appears, as I said, 2.5 years later, 2.25 years later. He's got a completely contradictory background. He obviously cannot be a sole reliable witness. Of course, he can be a witness if your lordship finds lots and lots of corroborative evidence. But Manoj, the main thing was the documentary evidence. The learned judge, I showed this also to your lordship last time, brushed it aside in 2 sentences saying, yes, it is there. We will see it at the end of the trial. We will see it later. So documentary evidence is out. Yaji is in. Credibility, believability, corroborative is 0. The documentary evidence, if it is inadmissible or not valid, had to be dealt with at this stage. Because whereas you are using Yaji to convict me, to deny me non-suspension of the conviction, then whereas documentary evidence can't be brushed aside like that. That's the point.
Lord, today also, Mr. Nanavati has only.
And my lordship has heard today, I was told when I was coming in the car here, that Mr. Nanavati's prime witness is the magical Mr. Yaji Mills. Rightly well, I mean, he cannot find a new witness now. Whatever is there is only this. With all his forensic ability, even he can't find a witness.
I don't want to eat.
Malas, therefore, even today your lordship has got only this Yaji. He's a very infirm basis to not give me suspension of sentence. The sessions court, forget the trial court. I will win by trial, I will lose by trial, etc. The sessions court has to deal with it, Malas. Otherwise, what's the point? Then, Malas, kindly see that just a few more things, Malas, I am done. I have made the point about the 65B certificate.
Yes.
Your lordship has noted it down.
Yes, sir.
It is well considered a technicality, but there are case after case after case, especially after Justice Nariman's judgment of the IT Act, that it's a mandatory provision. It's not that it's just something your lordship thinks it's technical and brushes it aside. Please produce 3 things. 1, maker certificate prepared by the maker of the CD. There is a CD, there is a maker of the CD, and there is a certificate. Where do the 3 match? Please show to the court. And the certificate issued while producing the CD in open court, it is admitted in writing at page 52, 53 of the CC that the CD was in open condition. Open condition, my lord, remember. Well, let me come to a more important point as I wind up, Wallace. The more important point is that your lordship, Wallace, ultimately, I have, Wallace, the duty to, Wallace, request my lords to consider and decide the suspension one way or the other. Wallace, at your lordship's immediate and earliest convenience. Well, I am here seeking a stay. I am gravely and irreversibly prejudiced without a stay. In my humble and respectful submission, Wallace, it brooks no delay. We have now, everybody has argued. Your lordship, Wallace, may kindly take a call this way or that way. Your lordship, Wallace, may appreciate that denial. And of course, my lord is entitled to do one other thing subject to that. My lord is entitled to give an interlocutory decision and then a final, which is not normally done. I'll be very candid, it's not normally done. But Wallace, some decision which clarifies my status today is vital. According to me, your lordship has heard us both at great length. Your lordship has seen at this level at 389, my lord is not a trial judge or a conviction judge or a acquittal judge. Your lordship is a 389 judge at the moment. Your lordship has seen enough. Your lordship should, come to a decision one way or the other. That is, my humble submission, because that justice would be required. Yashwant Sinha's case was, a Supreme Court order. It was in existence at the time of sentence. Now, that is what they are saying. I am asking myself one question, on Yashwant Sinha's case.
671.
Yes, yes. This is fully dealt with at page 671 of my written submission. If you also just turn to that for a minute. Because this is again something apart from Yaji, my learned friend relied a lot on Yashwant Sinha. I repeat, my experience is more limited. There are people here with criminal law more experience. I have yet to find a conviction in defamation at all, or if at all, more than 3 to 6 months. To say that maximum punishment is desirable, what is it desirable for? It's a first-time offender. How is maximum punishment desirable? And how many defamation cases has the lordship found where 2 years is imposed? I mean, your lordship, in the sense, appellate court, but it's coming from below. Your lordship doesn't hear the trial. There is no defamation case that I know where the maximum punishment imposed for the first time. And your lordship is told that we have to cite a case to show that this is the most apposite punishment. Yashwant Sinha cannot be an apposite punishment test. Now see, 671. Written submission, just turn to the. But there is not a single reason given factually or contextually as to why Yashwant Sinha mandates that your lordship gives a maximum of 2 years, because 1 year, 11 months and 29 days is not enough. Therefore, give 2 years to a first time offender for a bailable, non-cognizable, anti-societal offense. There's no reason given to your lordship. It's just said Yashwant Sinha, Yashwant Sinha. Now kindly see 671. I mean, Singh, it's not Yashwant Sinha. I'm told it's Yashwant Singh. I see.
Yes.
The same man.
Yeah.
It's the same, the political.
I have not.
The most disturbing,
In
just see
fact, he has
671. I thought there's a mistyping here. It's Singh here. It's actually Sinha. The most disturbing feature of sentencing part is the manner in which the prosecution placed reliance upon the judgment in Yashwant Singh and the uncritical manner in which the court readily signed the dotted lines. It has been pointed out in the memorandum of appeal that the said judgment would not have any bearing or relevance to the question of sentence in the present case. Now, this is the answer. Because the law applicable to the present case does not permit reliance upon observations made in a case of contempt of court. The lordship is doing contempt of court, well as apples and oranges or well as bananas and oranges. However, the real pain of the appellant lies elsewhere. The question speech relating to the institution of the present prosecution was made on 13th of April. The name of the appellant figured in the Supreme Court because of the alleged content much later in the year. This point I made, Manas, 6-9 months before and subsequent. The appellant was warned and told to exercise caution in future on 14/11. It baffles comprehension how for a warning on 14/11, the appellant could be expected to be wiser on 13/4. Retrospectively, I said last time. Therefore,
So they have said.
well, it's the what is recorded in the order is that when I'm giving you something more because you already stood warned on the date of giving you the punishment. Yashwant Sinha being present is neither here nor there. It's irrelevant. The jurisdictional error is, fellows, that the trial court is saying, I'm punishing you, Mr. Accused, because you were earlier warned by the Supreme Court. You stood warned. The dates show that, fellows, there is no correlation at all. It's much later. Therefore, the answer can't be that on the date when I'm giving you the punishment, Yashwant Sinha has come. It's irrelevant, fellows. The 2 and 2 don't add up together. Whereas I would say, fellows, at the end of the day, just give me a minute. Just give me a minute.
In keeping with
Don't worry. Don't.
my apology.
Whereas this, I will move the application for suspension of sentence. Suspension of sentence, whereas here, your lordship. Perhaps here,
We are
lordship
not
need not
imposing
grant,
it.
whereas for at least till the
In
rising of
High
the
Court,
court.
perhaps we are not now
Till the
imposing
rising
any
of the court, your
penalty.
lordship need not suspend the sentence.
Another even convicts the mistake.
Malas, if Malas, these considerations form a part, as I've shown, then Malas, it becomes very, very, well, I've also shown a whole set of 6 circumstances of vitiating of the trial. This Malas raises a grave doubt and apprehension about the purity and the fairness of the trial. I would beseech my lord, Malas, this way or that way for your lordship to decide the matter and give Malas quietus to this. And any delay of a single day, Malas, would Malas cause us.
In fact,
extreme-
now, therefore, we have made clear that we have heard total all the parties, and now we are keeping for judgment only.
I know,
During
but
the-
I'm
during
making
these
one.
holidays, we are using all these materials, and we are finally deciding. That's
Malas,
all.
there is only one request. There
Yes.
is only one request. I mean, I hate to
And
make.
today again, the Honorable Apex Court has raised the very issue in the case of Muhammadullah Azam Khan. And the court has kept this matter in the month of July, where they have raised the very question.
Well, I am the counsel there.
Yes,
They
therefore,
listed today.
therefore
three
I have
item
read
18.
that, therefore I am
I
now.
was to submit
No,
that,
no,
but
no.
my lord, it
No,
is
no,
all,
no, no.
once it is sub judice,
The
it is
court
sub
has
judice.
already
Either
posed
way.
that very
I-
question. And what is the offense in that Muhammadullah Azam Khan?
Murder.
No
Oh,
murder.
well, not murder. Sir.
Not
Grievous
murder.
hurt.
He is
Grievous hurt.
just sitting on the road with his father, therefore the
No, but it's
FIR is registered
Grievous,
against him.
grievous hurt. Grievous hurt.
That
Grievous
is
hurt
in
case.
the second.
10
But in
years.
the first offense, it was registered as,
No, but
he is
I-
only aged 15 years at the relevant point of time.
Well, he is given
That's
10
all.
years there and the High Court suspended the conviction. We are respondents in the Supreme Court. The other side is complainant has appealed. And that matter was today listed as court 3 item 18. I was to
That is
argue it,
what I
but
have
I have
read.
come here.
Hurriedly, and therefore I am just,
Mine was yesterday's matter before Malad went Mr. Sipala.
yes.
That was a different matter where Malad that skipped in July. That's different than
No,
this.
no, no. Today, well, I don't know what happened when I came here. Today matter is listed before court number 3 is Justice Joseph's court. Where
No,
well,
that
I
is
have-
not the matter yesterday.
Ah,
was
that
different.
is now-
What I
that's
was
a
saying is
different-
when the son was
But
sitting
anyway,
with his
Milord,
father.
That is all.
But-
They are all
but- but I'm
pending.
not concerned. I'm on a
Arguments
different
are
part.
going
No, no, in that one is the sentence stands suspended. The matter which I
Yes,
am doing.
Kerala High Court
Where the,
did that.
where the High Court of Allahabad has rejected and refused to entertain,
yesterday.
therefore they are
That-
approach.
That's right, but then I can equally cite, no, kindly see, I can equally, I'm entitled to cite
Yes.
that the Kerala High Court suspended it. After suspension, for 1 month, the Malus Lok Sabha did not allow him to enter the. We Malus moved an application to court 3. On the day I moved the application, the Lok Sabha Malus came through Mr. Mehta and said, today we are allowing him to enter. So the disqualification lifted. It was immediately stayed and lifted. Now, Malus, I was different unpleasant duty to perform. Malus.
Yes.
I don't want to.
Hmm.
Malus, it's my duty as a council to Malus, request my lord to consider giving us Malus, an order this side of the vacation because
This
Malus,
is
we
not
are
possible. In fact, when first occasion I have clarified that on 4th I am leaving the country and therefore I am unable to
No,
pass.
that is true.
Sir.
Your lordship Malus may only record then my submission.
Yes,
I'm only
certainly.
Malus saying
Yes.
that Malus, for all the reasons I've argued,
Hmm.
Malus, Malus, either interim or final order is required because everybody.
We
Malus, is
pass
going
the
to
final
recess.
order only after.
Yes,
the opening
your
of
lordship may only
vacation.
note my submission, Malus,
Yes.
this is a contention.
You're
I have.
only there, I may just.
Yes,
This
Permit
is very
you.
clearly my submission.
yes.
Then your lordship has also called for the recording.
I have already called for. the
Now,
record.
therefore,
Yes.
you know, when the matter is being finally heard and being decided, you know, this prayer is out of place in my respectful submission.
We are
That's
So
all
my
right.
objection may kindly be noted.
My learned friend Abhishek has certainly been noted.
And
Similarly,
that will
my
amount to
submission,
allowing the
Yes,
petition.
my submission
You
that
can
your
read about
lordship may
this.
Malus, consider deciding this side is fine, and we are in extreme emergency, is my submission.
Yes,
I am
yes,
only making
certainly,
that
that's we record. That till the next council meeting,
Without
Dr.
prejudice to all
Singh.
this, of course, we will file a written submission Malus, within 3-4 days in any case. That
But
we have.
now from 5th onwards, there is a holiday. Summer vacation is commencing from 5th. And
We
this
can file
court is,
it, no, can we file it by 4th?
but then I am unable to pass any order before that.
That's only for assistance, my lord. That's
You,
only
you can file.
for- that's
That
only-
I will
That's all.
go through the
Ah.
records and after passing and after going through your submission, I
Yes,
will
yes.
pass the order. You may.
One thing is,
Dr.
saying-
Singh,
Not just one,
yes,
Lord, sometimes they say, my lord, in hunting a long shot. One shot which was taken by very, Lord, revered friend is
yes.
that this is a case of moral turpitude. Look at the judgment my friend cited. Kindly
Yes.
have a look at that. It's my lord Sushil Kumar Singhal. The judgment should not have come. The argument, of course, is not made out. Lord, before my lords read it, my lord, the law is a judgment is not to be read like a statute. And the law further is a judgment is an authority for what it decides. And nothing else.
Yes,
Now, my lord, may kindly have
Hmm.
para 2. The facts and circumstances giving rise to the present case are that the appellant was appointed as a peon in the respondent bank, Cathal branch on such and such date. The appellant was handed over rupees 5,000 to deposit the same as due for telephone bills. However, it was not deposited and FIR under section 409. Now kindly see my lord to para. It is
yes,
a judgment which would my lord negate all that is being said. The para cited are my lord 32, which
Yes.
defines moral turpitude. Para 23 is cited. Let's read the para
Yes.
as it is.
Hmm.
Conduct that is contrary to justice, honesty, or morality in the area of legal ethics offences involving moral turpitude, such as fraud or breach of trust, also termed moral depravity. Moral turpitude means in the journal shameful wickedness, so extreme a departure from ordinary standards of honest, good moral justice or ethics as to be shocking to the moral sense of the community. it has also been defined as an act of baseness, vileness or depravity. Then Caesar para 24,
Yes.
same, and then also see in para 24, the second judgment. So all this is taking it to the extreme, to the breaking point. This all would negate and would show that this does not fall in that.
Senior counsel, Dr. Singh, requested the honorable court that since the honorable court has heard finally, then it is in the fitness of the thing that the interim order be passed in favor of the petitioner. In the interim protection be granted in favor of the petitioner. The learned counsel appearing for the original complainant, senior counsel Mr. Nanavati has objected this prayer. However, in the interest of justice, as the matter is heard finally, and all the documentary as well as the plethora of the documents is placed on record, we considered the same. It is in the fitness of the thing that the matter be decided finally. No interim protection can be granted at this stage. Only after going through the reports and proceedings, the final order can be passed. Hence, the matter is kept for final verdict after reopening of vacation. Matter is heard. Please.
Very deeply obliged. We are very deeply obliged for a very patient
Very
hearing.
patient. Immensely.
Once again, apologize. I'll handle it with your